$1 milliard qui a été consacré à ce
that has
plan
been
d'action.
consecrated to this action plan.
Passons maintenant à
Let's
notre
now
audit
move
des
on
impositions
to
liées à l'impôt sur le revenu.
the income
La loi
tax.
de l'impôt sur le revenu
The
est complexe
law of income
et
tax
les
is complex,
contribuables
and
ne sont pas toujours
taxpayers are
d'accord
not
avec
always
l'interprétation qu'en fait
do not
l'Agence
always
du
agree with
Revenu
the
du Canada.
interpretation of the Canadian Revenue Agency.
Notre audit a révélé que l'agence
Our
prenait trop longtemps pour
audit
décider
showed that
si
the
les
agency took
oppositions
too
des
long time if
contribuables étaient valables.
the oppositions from the taxpayers
Par
were
exemple,
valuable.
l'agence
For
a
instance,
mis
the
plus de
agency
5 ans
has
pour régler 79
took more than
cas
5
d'une
years
valeur de près de 4
to
milliards de
settle
dollars.
70 cases,
We found that the agency's time
several
frame
thousands
for
of cases to
decision on
$4 billion
straightforward files
of
was
amount.
about 5 months. For medium complexity files, the agency told taxpayers they could expect to wait up to a year before even hearing from an appeals officer. Furthermore, the agency's performance targets didn't consider timeliness from the point of view of the taxpayer. For example, the agency didn't count days that a file spent waiting for an appeals officer to be assigned. Overall, we found that in 65% of objections, the agency ruled in whole or in part in favor of the taxpayer. However, the agency rarely used these results to improve future decisions. In our audit of the Correctional Service of Canada, we found that as the Indigenous offender population grows, the Correctional Service can't provide them with the rehabilitation programs they need when they need them. More than 3/4 of Indigenous offenders were sent to medium or maximum security institutions. From these institutions, most couldn't access the programs they needed for their rehabilitation before the earliest possible date they became eligible for parole. As a result, the Correctional Service prepares Indigenous offenders for parole hearings less often than non-Indigenous offenders. Nous avons constaté que les deux
We have
tiers
found
des
out that
détenus autochtones
2/3 of
libérés n'avaient
the
jamais été
native
libérés sous
people
condition.
in prisons were not
La
freed
moitié
according
d'entre
to the
eux
terms.
sont
Half
été
of them
libérés d'un
were
établissement à
freed from
sécurité moyenne
a
ou
middle
maximale
security
directement
or
dans la
maximum
collectivité.
security institutions
Cela
directly
veut dire
into the
que
collectivity.
ces détenus
It means
ont
that
eu moins de
those
temps pour
people had
bénéficier
less
d'un
time to
retour
beneficiate from a
progressif et
progressive
structuré
return into
dans la
and structured
collectivité.
return into the community.
Les délinquants autochtones
The
sont
native
dans un cercle vicieux.
contraveners are in a vicious
La
circle.
plupart n'ont pas accès en
Most
temps
of them do not
opportun
have
aux
access
programmes dont ils
to
ont
the
besoin.
programs that they
Et
need.
parce qu'ils n'ont pas terminé
And
un
since they
programme
haven't
correctionnel, ils ne sont pas
followed
mis en
the
liberté
correct
conditionnelle
correctional
aussitôt
program,
qu'ils
they
devraient
are
l'être.
not put into the best conditions
Passons
as they should
maintenant
be.
à une autre
Let's
question
now
qui
move on
intéresse
to
la
another
Première
issue that
Nation.
of
En
interest to the
2007,
First
le
Nations.
gouvernement fédéral
In
adoptait
2007,
un
the
nouveau
federal
plan d'action
government has
appelé
adopted
la
a new
justice
action
enfant
plan called
pour tenter de régler les
Finally
revendications particulières
Free
de longue date.
Justice for Good, and then
Ces
it was to settle the long
revendications
date
portent sur
issues.
l'administration des terres de réserve.
It was concerning the reservation
Avec ce
lands.
nouveau plan,
With this
le
new plan,
gouvernement voulait régler
the
les
government wanted to
revendications
settle
particulières
particular
de façon juste et
situations with
transparente, de
in a
préférence par
true
voie
and
de négociation.
a fair and transparent way through
Il voulait
negotiations.
aussi
It wanted
régler
also to
les
settle
revendications plus rapidement,
more
par souci de justice pour les Premières
claims more
Nations
quickly
et
by
de certitude pour les gouvernements, l'industrie
worried
et
of
les
fairness for the
Canadiens
First
et
Nations and also for all Canadians.
Toutefois,
However,
certaines réformes ont créé
some
des
reforms
obstacles
created
qui ont
obstacles,
empêché les Premières
hindrances
Nations
that
et le
kept
gouvernement
the natives
fédéral de
and the
régler
federal
les
government to settle
revendications.
those claims.
For instance, Indigenous and Northern Affairs Canada changed its negotiation practices without consulting First Nations. It also significantly reduced its funding for First Nations to research and negotiate their claims. These changes made claim resolution more difficult. The department was aware of these barriers but didn't address them. The department publicly reported that the 2007 reforms were a success. However, in our view, most of the settlements used to support this assertion were either resolved or close to being resolved before justice at last was implemented. In fact, since 2008, as many claims were closed without resolution as were resolved. Now I want to address our audit of motor vehicle safety. Through the oversight of motor vehicle safety regulations, its monitoring of public complaints and vehicle recalls, and its investigations into alleged defects, Transport Canada plays an important role in keeping passenger vehicles safe. However, we found that Transport Canada hasn't kept the regulations up to date, so the department is lagging behind the pace of changing technology. For example, the regulations don't allow vehicles to be equipped with software-operated advanced headlights, but semi-autonomous vehicles controlled by unregulated software are currently on Canadian roads. It can take Transport Canada more than 10 years to update the regulations. Étant donné l'approche prise par Transport Canada pour établir
Since the approach used by Transportation Canada to look at the standards of vehicles, Canadians could be kept from some technologies that exist elsewhere for their security. We've also found out that Transport Canada does not only consult the manufacturers concerning the rules proposed. The department was not looking for investigations data on the security of those vehicles. In the first of two audits touching national defense, we have reviewed the recruitment and the maintenance of effectives in the Canadian Army. We found out that the Army did not have sufficient employees in certain professional groups to enable Canada to respect its commitment, national and international military commitments. 4 years ago, in the regular forces, we were missing about 2,000 members against the number that was necessary. At the end of our audit, we found out that this level was moving up to 4,000. In 2016, there were important lacks in 21 professional groups in the Army and high levels of lack in 23 out of them. The national defense must understand the challenges it faces in order to modify its recruitment methods based on the different professional groups.
The Canadian Armed Forces recruiting process fit its own needs and not those of applicants.